GDPR. I want to apologize as we're getting started here. We're just having a little problem uploading our first slide for our PowerPoint today. But in the meantime, I just want to get started. For the benefit of our listeners, my name is Katie Henry, and I'm the Executive Director of the Metro Milwaukee Association of Commerce World Trade Association. The World Trade Association is the state's largest network of manufacturers and service providers involved in international business. Our members benefit from regular educational programming with subject matter experts and networking opportunities. More information about the WTA can be found on our website at mmac.org/WTA.html. In a moment, I'll turn the webinar over to our presenter, Hubert Kirchgaessner, Information Security Matter Expert with Patina Solutions. But first, some housekeeping. Please be sure to mute your phones. Please hold your questions until the end of our presentation. Use the chat box at the right of the screen to input a question. I will be monitoring the questions and I will try to ask them for you. Our speakers' information will also be provided to everyone at the end of the presentation. Today's conference is being recorded. If you have any objection to that, you may disconnect at this time. Now I'd like to introduce our speaker, Hubert Kirchgaessner, MBA, CISA, CISSP, CRISC, Information Security Expert with our longtime MMAC and World Trade Association member, Patina Solutions. Hubert's passion is the management of information security risks, identifying what needs to be protected, which regulations need to be complied with, what you need to protect against, and which levels of risk your organization is willing to tolerate. Until 2017, Hubert served as a leader of the Information Security Governance function at Procter & Gamble, identifying the company's most critical information assets, setting the policies for the protection of these assets, performing threat and vulnerability assessments, evaluating third-party business partners, and building up threat intelligence were the main responsibilities of the department that he led. He is able to help organizations manage information security governance and risk management processes. He provides a range of consulting services, including guidance on information classification, threat and vulnerability assessments, selection of information security frameworks, and benchmarking of security maturity. Hubert, would you like to get started?
Absolutely, and thanks for the introduction. Can you all hear me?
We can.
Okay, very good. Can you see my slide, the Patina title slide?
Yes.
Excellent, very good. So, oops, wrong screen. Since we're not using a webcam, this is me here, Hubert Kirchgaessner, and you just got my the ins and outs of my bio from the introduction. Thanks a lot for that. I'm located in the beautiful city of Cincinnati, or actually just south of Cincinnati in northern Kentucky. And these days, because of GDPR, I'm literally traveling all over the place, mostly in the U.S., sometimes in Europe. I'm here currently representing Patina. You undoubtedly discovered from my accent that I'm not a native Patina person. No, sorry, that I'm not a native speaker of English, but I am, otherwise qualified to represent GDPR because, guess what, I'm European. But with 2 passports and long-time business experience in the U.S., I think I can easily think myself into the issues that we are facing here. All right, so this presentation is on GDPR. It's a European effort, and I'm going to get into more detail on that. But I thought I'd start with a goodwill, good feeling slide on what Europe does best. It's probably not legislation. It's definitely cuisine, all right. And the point about GDPR is that once again the Europeans have cooked up something, right? And it's a privacy or data protection legislation called GDPR, which of course stands for the General Data Protection Regulation, GDPR. And I'm not going to spend too much time explaining the details of this law, number one, because you can read it for yourself. There's going to be a PDF, a one-page PDF attached to the follow-up email that comes after this session. And this PDF gives you a number of mostly internet-based resources where you can learn more about GDPR. And one of those resources is actually a downloadable link for the law itself. So you can use that to, well, it's actually a good cure for insomnia, very few side effects. Not exactly thrilling, but if you have any specific legalese questions, you will either find them there or seek some legal help. I'm not a lawyer and I'm not playing one on TV either. But in general, what is GDPR? It's a law. It's a law that's passed by the European Parliament to be valid in the territory of the European Union, signed off by the European Commission, which is essentially the equivalent of a government for the European Union. Sometimes important to know is that this is not exactly new, at least not all of it is new. The GDPR law is replacing a 1994 vintage document called the Data Protection Directive. And even though there are quite a few new things in GDPR as a law, there's also quite a bit of material in there that is already existing law. And so if you fall under the scope, which is a question we will cover in a second, and if you are struggling to achieve compliance with some of those requirements on there, you may want to be careful and not claim too much that they are all new, because some of them might have been in place for more than 20 years. The way it's currently written, it is without any doubt the strongest privacy law in the world. And yeah, the last line on the screen here, it is going to be effective or in force as of May 25th, 2018. So real soon now, anytime real soon. Okay, not too much time left to become compliant. This is all about data protection. Now, what in the world is data protection? Most of us are probably more familiar with the term information security. So I'm giving you a little bit of an introduction here to the somewhat European term of data protection. What information security and data protection have in common is that they really employ technical as well as organizational means to protect something. Okay, an example of a technical control would be, I don't know, an intrusion detection system, a firewall, an access control system on your network, that sort of thing. Organizational security measures, examples for that would be policies, access regulations that you enact in a managerial way, trainings you provide to your employees, selection criteria that you employ when acquiring new systems or designing new systems, those types of things. The difference between information security and data protection really is more in what it is that it is trying to protect. Information security generally tries to protect your company's competitiveness, and it does that, and that's a bit of a simplification, but it does that first and foremost by keeping your company's secrets secret. Right? That's the broadly speaking the goal of information security. The goal of data protection is to protect the personal data, the privacy, if you wish, of what GDPR calls data subjects. And you may, whenever you hear the term data subjects, simply equate this with EU citizens. So this is the GDPR legislation is meant to protect the privacy of citizens of the European Union. This is almost certainly not the first time that you're hearing, hey, Europe privacy and European privacy laws, issues with complying with that, and Europeans having European subsidiaries, European business partners jumping through hoops to protect privacy. So you may be wondering, what exactly is it about Europeans and privacy? Why is that such a big deal over there on the old continent? And in a nutshell, the answer is history. Okay. History, well, not so much as the clip art suggests here of the shield and sword type of history, but more along the lines of concentration camps and gulags. Okay, keep in mind that in Europe not too long ago, it could mean the difference between life and death for quite a few citizens. Whether or not your personal beliefs, your ethnicity, your health was known to the right or the wrong parties, especially, of course, to the wrong parties. So the big reason that Europe and especially Western Europe, I must say, where the core of the European Union is, places such a high importance, such a big emphasis on privacy, really is the historical experience of the totalitarian regimes of the 20th century. And you may argue slightly east of the European Union, we probably see this in action these days. But the snap answer to what's the deal with Europeans and privacy is history. Okay, this is where this all comes from. Folks are very passionate about this. They are very protective of their privacy rights. As a European who has lived in the US for about 20 years, I still cringe whenever I'm being asked for my social security number. Maybe something that comes more natural to you, but I'm carrying the legacy of European history there with me, even though I haven't lived on that continent for quite some time. So GDPR is meant to protect privacy, meant to prevent this, for example. Okay, you probably all heard of the famous Equifax hack, where, as we now learned, more than 160 million records were being stolen, containing pretty much anything that you might find worth protecting when it comes to your personal privacy, including things like driver's license numbers, social security numbers, bank account information, and so on, credit card numbers even. And the amazing part is that even though there was a congressional investigation started, really that investigation just stopped. There was no follow-up to it. There was no penalty for it. And for Europeans, this is probably one of the exhibits of why a legislation like GDPR is needed. This year would be another one, by the way. The fear, if you wish, in some cases more emotional than real, of constantly being spied upon and being unable to function as an independent citizen and perform your own decisions because of spying on your privacy. This is what GDPR is all about, really. All right, I mentioned it repeatedly. GDPR is a European legislation. The scope, the jurisdictional scope, first and foremost, is within the European Union, the 28 countries that make up the EU these days. 27 past Brexit, but we are not there yet. And the first question to address here is the famous but wait a minute. This is European law, European legislation enacted by the European Parliament and enforced by the European Commission. Now, we are, of course, not Europe, all right? And I realize that. So it brings up the obvious question, why should we care? And the answer to that is, well, really twofold. The first one is, with many of my clients, upon further research, we find out that they're actually more European than they think. Not with all of them, but with quite a few of them. And I'll get into more details on this in a second, but in general, if you have organizational representation in the European Union, you are almost certainly a what the law calls a data controller in the sense of the GDPR legislation. Second, the GDPR law explicitly has worldwide applicability. The European Commission, the government of the European Union, and the European Court of Law, the equivalent of the U.S. federal court system in the EU, are explicitly instructed by the law to perform a global enforcement of these regulations. And that brings up a question like, how in the world are they going to do that, right? I'm getting a message here. Can you change the screen to your slides? Can you not see my slides? Can somebody give me a feedback there?
That was very old. Keep going.
Sorry for that. Okay, so the question we always that I typically get within the first hour of consulting someone on GDPR is, okay, I'm US based. Okay, my business doesn't have a representation in the EU. So how does the EU Commission and the European courts, how do they want to enforce that law with me? The answer to that is actually fairly obvious when you think of the reverse situation. The United States has, for many years, for several decades, enforced our trade legislation more or less consistently on a worldwide basis. So it is not unusual that legislation like antitrust laws, like money laundering laws, and a couple of others which are in their core US laws, that these are being enforced on a global basis, that organizations like the FBI is performing prosecutions in places like Turkey to determine violations of money laundering laws, or that individuals who perform particular business practices that we regard as violating antitrust laws in places like Asia or Western Europe, that they get sued in US court, generally in New York City, for violating US laws. So now that in some degree, to some degree, this GDPR law is basically putting that shoe on the other foot and saying, well, we can do the same thing. The question of how are they going to enforce it, of course, is calling for speculation, because that particularly is not known at this point of time. The law isn't even in effect yet. There is no case law experience yet of that. But think of the following options. Just like we do with enforcing US laws outside the US territories, the Europeans can try to prosecute and even arrest people when they get a hold of them. They can issue arrest warrants with Interpol, just like we do with enforcing US laws globally. They can obviously impound any assets that your company has within the territory of the European Union. In more severe cases, they can go on after personal belongings of company officers, including board members, that, again, they can they can impound within the European jurisdictions. So the question as to how exactly is this global enforcement going to be played is an open one. It's probably an interesting one, but at the same time, my advice is you don't want to be the one who finds out for yourself. Okay. There are certainly options, and we have led the way there for decades on showing folks how to do that. How exactly this global enforcement is going to play out remains to be seen, but there is a mandate by the EU legislator, the EU Parliament, to perform global enforcement of that. And we'll have a special slide on this one. The legislation is explicitly designed to have severity, to have teeth, if you wish. The penalties that the European Commission can assign based on GDPR are quite severe. Now, as far as the global validity of this law is concerned, I think this is pretty much the only time I'm actually quoting the law itself in the on my slides here. Article 3 sets out the territorial scope, and I'm not going to read it to you, but there are 2 sections on there, 3 really, and looks like I've cut one off here. I apologize for that. But number 1, of course, says if you are established as a company in the union, meaning the European Union, then okay, you're in the scope of this. Number 2, if you are offering goods or services to data subjects, like I said earlier, EU citizens in the union, in the European Union, then you are in the scope of that. Or if you are performing monitoring of behavior of data subjects or European citizens that takes place within the EU. So what does it mean? Number 1 is the easy one. If your company has a physical representation in the EU, if you have a legal entity that is, for example, registered in Brussels or in London or in Frankfurt or God knows where, then you have a physical representation in the EU, and your company as a whole, not just that subsidiary, falls within the scope, the territorial scope of this legislation. Number 2, assuming you do not have any organizational representation in the EU, however, you are offering goods or services to EU citizens, which via the internet these days is a lot easier to do than it used to be. So if you are offering, specifically offering via internet-based businesses, internet-based selling goods or services in the EU to European citizens, then you fall under the territorial scope of this law. Keep in mind that the law explicitly says here, this includes services for which no payment is required. So obviously, if you're selling something against money, yeah, but that makes intuitive sense. You are, you may not have a physical presence in the EU, but you are basically trying to sell in the European market. But as far as this law is concerned, you would also fall into the territorial scope if you're offering services for free, specifically services that implicitly or not collect personal data. So examples of this would be Gmail, Facebook, Skype, product review sites. I have a client who is producing outdoor material for folks who love to go camping, hiking, Boy Scouting, that sort of thing. You would all know the name of the company if I said it. And they are not selling their products in the EU, at least not directly. They are selling the products to resellers who then sell it in the EU. So they are fine as far as number 2 is concerned because they are not selling their products directly. However, they run a website which collects product reviews on a global basis on one and the same site. And some of the products they are selling could be considered a little bit personally sensitive, because if you're buying them, you can assume certain physical restrictions, handicaps, and so on. So their concern, confirmed by their lawyers, was that the fact that they are offering product review services on their global US-based website basically means that they're falling within the second notion of the territorial scope of this one. And obviously their way out of this is to create separate product review sites for the European market. That is, by the way, data segregation is a fairly valid way to achieve compliance with that law. And then finally, the point number 3, the monitoring of behavior. Obviously, this refers to physical as well as logical behavior in the sense of physical behavior. If you're collecting somebody's GPS track logs, this would be an example of physical behavior, as would be monitoring shopping trends. If you are attributing shopping behavior to named individuals or individuals that could be individually identified, then this would be behavior in the sense of this law that you're monitoring. But something as innocent as website cookies, for example, would almost certainly also fall within the definition of territorial scope for this law. So, in other words, if any of those ring true for you, then your company is almost certainly in the scope of this law. Quick summary: when would the law apply to you? Like I said, if you have a EU-based subsidiary, if you systematically collect or store data of EU citizens, which includes, by the way, you buying this data from a third party, like Nielsen, for example, or GfK, or consumer research agencies like this. If you buy individualized data of EU citizens, you are within the scope of this law. If you're offering data processing services to companies that fall under those requirements, so let's say you're a cloud service provider, you provide internet-based technology services like Gmail, Google does with Gmail, for example, you would fall under this law. If you have an e-commerce website that explicitly sells within the EU, again, you're in scope there. So my recommendation is assume that that this does apply to you until such a time as a lawyer who really understands this law explicitly tells you no. All right. Until that time, I would assume that you're covered. This is a little bit cautious, but you better want to be careful there. All right, so I mentioned earlier that GDPR is not all new. It does replace an earlier law that has been in existence for a bit over 20 years. And that 1994 law also replaced something that had been there before, but that's besides the point. So what exactly is new in GDPR? I mentioned the global enforcement. That didn't happen before. The EU data protection directive, which GDPR replaces, was intentionally or not always only enforced within EU and against EU entities, so European subsidiaries, individuals residing within the territory of the European Union. Number 2, it applies to all personally sensitive data. And what this is referring to is, again, whether intentionally or not, the old EU data protection directive was only ever enforced against structured collections of data, which is a fancy way of saying people who maintain databases. So what this meant was, if you kept a database with sensitive information of European citizens of the EU, then yes, you fell under the scope of the pre-GDPR law. However, if you kept this information in unstructured form, in email or in Word documents or whatever, notepads, then you got to pass. Okay, that is no longer the case. The GDPR law explicitly enforces all electronic and physical collection of personally sensitive data, structured or not. GDPR does bring up a number of new work processes. Strictly speaking, it establishes a number of new rights for European citizens, and we'll get to those in a second. But from the point of view of your companies, for each one of those rights, you need to have a corresponding set of work processes ready in your company. Should any of the European citizens that get those rights try to enact them versus you, and we'll get to this in a second. Severe fines, I'll talk about that, and a slightly broader definition of personal data. So I'll put this up on the slide here. Article 4 of the law basically says personal data is any information relating to an identifiable natural person. This is a little bit more intricate than it sounds, because the scope of this definition goes beyond identifiers. It explicitly says any information relating to an identifiable person. So identifiers like numbers, names, IP addresses, email addresses, MAC addresses for network connections, network node connectors, and so on. Yeah, those would be identifiers, as would be physical addresses and so on. But the law explicitly extends to information, to any information that relates to these individuals. So even if you collect information that is not identifiable by itself, if you combine it, or if it could be combined with identifiable data, then again, you fall into the scope of this law. So this explicitly covers things like physiological attributes, genetic attributes, 23andMe, biometric attributes. One of my clients is collecting fingerprint information for access control to data centers. This would count as, number one, an identifier. That's what it's meant to be. And number two, of course, as a physiological attribute. Again, the solution for them to avoid coverage of that law for all of their databases, all of their systems, was to segregate the European access information into its own databases. But compared to the previous data protection directives, the definitions of what is personal data, what is sensitive data, what is data that is being protected by this law, have been broadened significantly. Interesting part here is the economic identity of somebody. So if you're collecting data on spending habits, income, investable assets, that sort of thing, you definitely fall into this, as you would if you collect information like, I don't know, sexual preferences, health information, ethnical identities other than national identities, these sorts of things. I mentioned the magic word fine a number of times. Well, here are the fines that the legislation threatens people with. The EU courts can assess you if, obviously, they have gone through a judicial process and identified that you have violated that law, they can assign fines to up to the larger of 20 million euros, equivalent of $25 million roughly, or 4% of global group revenue. Okay, the latter one is typically the killer figure. So my previous employer figured out that this corresponds to $3.6 billion, a figure that gets everybody's attention, I would guess. So severe fines on that one. Like I said, the best way to get out of this is to ensure that you are either outside the scope of this law, or if you fall within the scope, that you achieve compliance. The rest of the presentation is going to be about what does compliance look like. And you see a couple of key terms mentioned here: the data protection officer, data discovery, consent purpose, the new work processes. There will be detailed slides on each one of them, so let's jump right into it. Not everybody needs one, but my recommendation as a consultant is, if you fall within the scope of that law, by all means appoint a data protection officer. The law gives you a couple of requirements. Basically says if you have a legal entity within the territory of the EU, so condition 1 of those 3 conditions that would make you subject to that law, then and only then do you legally need a DPO, a data protection officer. My recommendation is if you fall within any of the 3 conditions for compliance, appoint one anyway, even if you wouldn't have a legal necessity for it. What does the data protection officer do? What is he or she meant to do? The DPO is meant to be your company's liaison with the data protection authorities. In other words, the government agencies within the European Union and the member countries of the EU that are responsible for protecting the privacy data of their respective citizens. They have different names, and the legal document, the GDPR, lists all 28 of them, actually 29. Each member country has one such authority, and then there's one on the federal level, if you wish, the EU level. But generally, those are government agencies comparable to what we would consider the Department of Trade or an organization like that. The DPO, the Data Protection Officer, needs to be based in Europe. Needs to be registered with the DPA, preferably the one in Brussels plus the one in the country where the DPO resides. And the reason that becomes relevant is that the moment you have designated a DPO, all conversation between the Data Protection Authority and your company flows through that individual. That individual can actually also be an organization, doesn't have to be a natural person. This individual does not have to be an employee of your company. Very often with US companies, they are not. Frequently, those are outside lawyers or outside information security experts. But recommendation number 1, if you fall within the scope of that law, appoint a DPO. Do yourselves a favor, spend the extra bucks necessary. They are fairly affordable. Don't skip on this one. This is going to save you so many headaches later on. Number 2, data discovery. One of only 2 processes that the GDPR law explicitly requires. What is data discovery? Well, it's very simply stated a work process where you identify which data you have, where you store it, and how you process it. Of course, in this case, we are specifically talking personnel data of EU subjects or European Union citizens. So we're not talking any old marketing data, technical data, engineering data, or whatever, but we are specifically talking data that falls under the scope of this law. This covers, I mentioned this earlier, structured data, information in databases, as well as unstructured information. Think of stuff you keep in email or in Word documents, SharePoint sites, that sort of thing. There are generally two ways to perform data discovery. One of them is analytically, which is basically somebody sitting down on a tabletop exercise and going through how we collect data, where we get data in the scope of this law from, how does it come into the company, what do we do with it, which applications, which servers, which network nodes are used to process this this data. How does it leave the organization? Is it getting exported anywhere? Is it getting stored anywhere? Is it getting backed up anywhere? So in other words, where could and should this particular data reside? That is the analytical approach. The technical approach is to use a particular tool commonly known as a data crawler, and there's a whole bunch of fairly good ones on the market, some of them even as freeware, that basically you give them particular data patterns to look for. So I don't know, maybe the data pattern of a Belgian driver's license number, or of a registration number with the UK National Health Service. And you instruct this data crawler to go through all of the shares, all of the servers, all of the data storage that you have, and see where it finds data that conforms to this particular format. My recommendation is please do both. Okay, by all means, perform the analytical approach on this one. Not something that an outside company that comes in and performs a data crawl can alleviate you from doing. You always want to do the analytical exercise, but by all means also do the technical version of this. You'd be amazed, or so far I haven't seen any company that wasn't amazed by the results of the data crawler exercise. Amazed as in, we would have never thought that you find blah, blah, blah here, or in this particular share, or on that particular NAS, the network attached storage device, and so on. Policies, third approach here, they concern more instructions to your employees in regards to what you can actually do with that information, who is entitled to hold it, and so on. DPIA, Data Protection Impact Assessment, is the second instrument that the law requires you to do. This is basically a risk assessment. Very important when you put new systems online, when you use different applications, new technologies to process and store sensitive information. There is a particular risk assessment that you want to have somebody go through to evaluate whether or not this technology, this process is fit for use in this particular data. There's a number of templates available for that. DPIA is by all means a science in its own right. As I'm not going to bore you with the details on that, but the handout that you're going to get after this presentation gives you a couple of pretty good tools that I've used successfully more than once. Consent and purpose. Not unlike some data, some privacy legislation that U.S. states like California and New Mexico have enacted. New York is about to do that. Essentially, what you want to have is what the law calls clear affirmative consent action by the data subject. So you're not going to get this by giving somebody a screen form with certain boxes already ticked, and unless they untick them, then they have consented. This wouldn't be affirmative. Okay, affirmative means a positive action, not the absence of a negative action. You probably also don't get this by bombarding people with 28 screens of small font data, and then at the end there's a button that says I agree. You want explicit affirmative consent, and by the way, you also want to store this. So make sure you keep a record of somebody giving you consent to collect and store their data. And purpose, again, this is not dissimilar from the California data, privacy law, SB 1386. You want to collect data for a clearly stated purpose, and you will have to delete it once that purpose is fulfilled. Cross-border transfer, you want to be careful with that. Generally, transferring data within the confines of the EU isn't a big deal. It is a big deal once you take data outside the EU. Take note that the former practice of safe harboring no longer applies. There is the new notion of a privacy shield arrangement, which can be pretty helpful, but it's not a one-to-one replacement for what we used to do with safe harbor. There is a relatively small number of countries that the EU regards as being equivalent in the level of protection that they have for privacy data, and therefore you can fairly freely transfer EU data into those. Canada, by the way, falls into that list. The US, unfortunately, does not. So if you want to transfer data between personnel data between EU subsidiaries and data centers in the US, you have to be careful. And then finally, once you have all of that done and no mean feat, then the other thing you need to do is perform information security really well. What does that mean? Well, I already mentioned that there are really only two explicitly described processes in the law. The statements that were issued together with the law coming from the legislative arm of the European Union were explicitly, we want to write a law that does not provide a checklist or a direct cookbook. There is no magic tool that you can buy from a vendor, and once you install it, then you are compliant. Several tool vendors approach people with that promise. It's a lie. Don't fall for that. Okay. What you do need, however, is, like I said, strong information security, obviously also applied to personally sensitive information. And you can get some ideas here on what strong information security means. I mentioned several times those famous new work processes. Here's where this comes from. The GDPR law gives citizens of the European Union a number of explicit rights, 6 of them to be precise, and they're all listed here. They have different names. People refer to them with different monikers, but the gist of it is what you see on the screen here. So if I am an EU citizen, I do have a right to receive a copy of my stored information. And by the way, if you are working in setups that are security relevant, that have any relevancy for, let's say, UK national security, or if you're legitimately have to store information about criminal behavior and so on, there are exceptions for these types of situations. So I cannot simply go to a company and say, hey, I know you have super secret information on me, can you tell me whether somebody suspects me of wrongdoing or somebody suspects me of being a foreign spy or anything like that. But I assume that none of the companies represented in the call today fall under those exceptions. So right number 1 is an EU citizen can phone you up and say, hey, I'm Joe Smith from Leger in France, and I assume or I suspect you might have data stored on me. Can you please tell me what data you have stored on me? Please send me a copy of the information you have on me. Needless to say, you need to have a work process in place that enables you to do that. Okay. Related to that are numbers 2, 3, and 4. If I get a copy of my data and I find out that there is something wrong on there, and I don't know, maybe the data says I'm right-handed, but I'm left-handed, or that I have German citizenship, but what I really have is both German and American citizenship, or is anything that amounts to incorrect data, I have a right to get this corrected. I also have a right to have my personal data that you store transferred to a third party based on my choosing. Imagine that you run a hospital, you collect certain health information about me. You couldn't simply share this information with anybody else. That part is easy. However, if I choose to go to a different hospital or a particular physician, and I want that physician or that new hospital to have access to the data, to the medical data that you collected on me, I can instruct you to have this data transferred to that new entity. That's what number 3 is about. Request to stop processing of my stored data. Obviously, that refers to a situation where I no longer require or use the services that you collected this data for in the first place. Have the data deleted, also known as the right to be forgotten. Our friends from Google fell over that hurdle a couple of times and paid pretty bad fines on that one. The last one is a pretty good one. I have the right to call you and say, I want to be excluded from fully automated decision making based solely on my stored data. This is commonly known as the no profiling requirement. So think of decisions that we make or that our companies make based on stored data. Think of credit decisions. Think of permissions that we give. Think of customers or services that we either extend or do not extend, choose not to extend. The EU citizen has a right to call you and basically say, hey, I want a human being to have a look at my information, to have a look at my case, and have a decision made that is not solely based on data stored in your databases. You get the idea via Santa here on what this means in the famous naughty and nice list. What all of these processes have in common are 2 things. Number 1, you need to have those as predefined work processes ready in your company the moment somebody calls. Okay, and this can be fairly non-trivial. And the other thing that they all have in common is that all of these are really hard to do unless you have a reliable data inventory. That's where the data discovery comes into play that I mentioned earlier. There's a couple of things that I don't want to go into detail on that are not particularly new, but the law, the GDPR law emphasizes them. Breach reporting, security by design, that is a good one. You need to be able to show to an auditor, for example, that the systems you designed, the systems you acquired, the systems, the applications, networks, and so on, that you use to store and to process this personally sensitive information, that they were created, designed, architected from the ground up to be secure. Okay, and the best way to do this is to perform a data protection impact assessment like we had on the previous slide, and document. By all means, document. Keep those documentations. Okay, you'll be glad you do. Couple of obligations. We will, of course, share those slides here. pretty much a repetition meant to be a one-slide summary. I do have 3 more slides dedicated to how you achieve compliance. Okay, the previous slides were meant to give you pretty much an idea of what you're up against, what it means to become compliant. Here's the how. Okay, this is the approach I recommend to get started, and I dearly hope that most of you have already done that. Okay, we're 3 months out, and there isn't too much time left. But number 1, verify whether you're in scope. Use outside counsel if you don't have the expertise in-house. But obviously, if you do this and the answer is no, we are not in scope, good. Okay, peace. Number 2, establish a top-level leadership behind this. Get your company's board and C-level management behind it. Name a DPO. If you want expert help, if you need expert help, if you do not have the necessary expertise for performing all of these things and performing them within 3 months, by the way, inside your own company, get outside help and do it quickly. Okay, you don't want to wait until the 1st of May to look for experts who can help you with data discovery. Those resources, folks who know what GDPR means, who can design a GDPR program, those are few and far between, especially in the US. And most of them are booked out already. Okay, so act quickly if you need outside help. You want to name a program manager. You want to, if necessary, refresh your memory on what is a program as opposed to a project. And you want to initiate and kick things off. Okay, what does a successful GDPR program look like? A couple of ideas here. Any successful GDPR program that I have seen was a multifunctional effort, meaning it combined expertise and resources from some of the parties that are listed on the slide here. It always had top-level priority and top-level support. It was led by a doer, not a politician. Okay, you want somebody to lead this program who knows how to get things done. Doesn't necessarily have to be somebody with particular compliance expertise, but somebody who knows the levers to push and the knobs to turn to achieve results. That's the individual you want in charge of this program. Every single one of the successful programs I have seen really kicked off with a thorough data discovery. And the good piece is that every single one of those actually ended up being very beneficial. Okay, couple of do's and don'ts. Quickly name a DPO. You don't want to give this to people who already have their plate full. You should expect to get lasting benefits out of that, as opposed to run something now, be done by 5/25 and forget all about it. And I already mentioned perform a quality data discovery. Last slide. How can you benefit from this? Well, very simple. If you play your cards well, if you do this the right way, you will put structures in place that protect more than just the personal data of EU citizens, but they protect your company's secrets as well. They give you kudos with your customers. They allow you to bid on EU contracts. And they, if done right, can really distinguish you from some of your competitors who didn't make those efforts. That's pretty much what I have here. Any questions?
Hubert, I don't see any at this time, and we actually have just ran out of time. We're at 12:30. So
okay.
I'd like to thank you and everyone for attending. I want to let everyone know that you will receive a link to today's webinar, which will include Hubert's contact information along with a brief evaluation. Please note that all WTA members will receive a separate link to the WTA webinar library, where they can access today's webinar as well as past ones. This concludes today's webinar. Thank you, everyone.
Thanks, everybody.
Thank you.